All right, what's happening with this case and why were you late for court?
I was late because of traffic.
Okay, you're whispering. I can't hear you.
Classic excuse traffic. But here's the thing. In court, traffic doesn't fly. Judges expect punctuality because if lawyers can't show up on time, it signals disrespect to the court's authority. And trust me, judges don't like to feel disrespected.
Traffic.
All right. So here's the thing. You have to be here at 9.
Yes.
So you have to realize that rush hour traffic is 9, really like 8 to 9. And then rush hour traffic going home is really like 5 to whenever.
That's one.
All right. So where are we in this case?
Judge, we've got a writ of habeas corpus to dismiss the prosecution with prejudice that we filed in this matter because this case has not been indicted. It's been more than 180 days. Does the court have a copy of that motion or that writ? If not, I've got one.
Yes, I have a copy.
Perfect.
All right. State.
My understanding, speaking with intake, they have dismissed this case today for their investigation.
All right. It's been.
Well, Judge, I've got a problem with that because.
Now here's the legal clash. The defense wants dismissal with prejudice. That means the case can't ever come back. The state, though, they want a softer dismissal, so they can regroup and maybe refile. Big difference, one shuts the door, the other just slams it halfway.
Under 28.061 of the Texas Code of Criminal Procedure, we're entitled to have it dismissed with prejudice. And I'm sure that the state has not done that based on their indication
All right,
that
so
it's been for further
here's what
investigation.
the question becomes. When was it dismissed?
This morning.
Okay. All right, just give me a moment. All right, defense has filed a writ of habeas corpus to dismiss prosecution with prejudice. State, have you had a chance to review the document?
Yes, Your Honor.
State, are you ready to proceed?
Yes, Your Honor.
All right, I'm assuming you're all proceeding on argument.
Yes, Judge, I do have some very brief testimony that I do need to elicit from my client.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Precious Ramirez.
All right, be sure you keep your voice up so that the court reporter can hear.
Okay.
All right, defense.
Thank you, Your Honor. You've already stated your name for the record. Ms. Ramirez, when were you arrested on this charge?
November 4th
Of?
of last year, 2023.
Thank you. And when did you bond out?
November 5th of last year, 2023.
Notice how the defense carefully walks the juror here, the judge through dates. Arrest, bond, indictment, deadline. This is like building a clock. If any piece is off, the whole thing falls apart. Dates are everything in speedy trial law.
Okay, and have you been indicted or been served with an indictment in this matter since then?
No, sir.
No further questions, Your Honor. Pass the witness.
No question.
And state, do you stipulate that the case has not been indicted?
That's correct.
All right. And is there any disagreement on the dates when she was arrested and when she bonded?
I don't believe that there is, Your Honor.
All right. All right. Any other evidence, counsel?
No other evidence, Judge.
All right. I'll hear argument.
Your Honor, based on,
Oh, and I'm sorry, just for the record, my understanding is that the state dismissed this case this morning, July 25th, 2024.
that is my understanding for what Mr. Garahan announced prior to our beginning of this hearing.
And I'm sorry, one other thing.
Okay.
What was the cause? What was the reason for the dismissal? Did it state?
Investigation for labs.
All right. So it was dismissed this morning for further investigation and because there are no laboratory testing done or completed.
Yes.
All right.
Thank you, Your Honor.
Vince, I'll hear your argument. Sorry for interrupting.
Not a problem at all, Judge. The defendant in this case is charged with the offense of possession of controlled substance, penalty group 2, 4 to 400 grams. She's been on bond since November 5th of 2023. There's been no indictment filed in this case. More than 180 days has passed since she was placed on bond since the commencement of this action to the date that we filed this motion. Neither the defendant nor I have missed any court dates or done anything to delay this prosecution. There's no good cause for any delay. The state is required to file an affidavit showing any good cause for the delay. No affidavit's been filed in this case. There's been no response to this filed by the state at all. As a consequence, what has happened is my client has a right to have her indictment presented pursuant to the Texas Code of Criminal Procedure, Article 32.01, and that's being denied to her. And we're asking this court to dismiss this charge based on Texas Code of Criminal Procedure 27.03 and to have that bail discharged. We also, for want of timely prosecution, we're saying that this case should be dismissed. Further, we're moving for dismissal to be done with prejudice, and that's.
Here's the high-stakes moment. Dismissal with prejudice means the prosecution can't just hit reset. Think of it like deleting a video file once it's gone. It's gone. No backups. The defense is pushing hard for this nuclear option.
The main reason we wanted to have this hearing. Even though the state has dismissed this case this morning, we're still within the 30 days to ask for a new trial. And I'm not even sure that that has actually been filed and processed at this point. We're asking that this case be dismissed with prejudice under Article 28.061 of the Texas Code of Criminal Procedure. That provides if a motion to set aside an indictment, information, or complaint for failure to provide a speedy trial is sustained, the court shall discharge the defendant. A discharge under this article is a bar to any further prosecution for the offense discharged and for any other offense arising out of the same transaction, other than an offense of a higher grade that the attorney representing the state in prosecuting the offense that was discharged does not have the primary duty to prosecute. We are relying on the holdings in Nix v. State. That site is 882 Southwest 2nd, 474. That's a appellate case from Houston out of the First District from 1994. The rehearing petition or the rehearing was denied in that matter. There's been some subsequent case history to that since then. I think the last case was in 1999, holding that both 32.01 and 28.061 are both constitutional and don't provide undue reasonable interference with the prosecution's duties. We're asking this case be dismissed with prejudice.
All right, and state?
Your Honor, this case has been dismissed, my knowledge, this morning for further investigation because the labs they're awaiting the laboratory results of the drugs to be tested. In that particular case, she is discharged of her bail. So at this point, she's not on bail and not on bond for this case any longer. There has not been speaking of a right of a speedy indictment, the fact is that there has been no indictment in this case, so a right for a speedy trial would not be attached at this moment, Your Honor. So the state's understanding of the code is that at this point, there's no indictment, it has been discharged, so the individual is not, should not be allowed for a speedy trial to be sustained in this particular case.
All right, defense, it's your motion, so I'll allow you to have final argument.
Thank you, Your Honor. Basically, to what extent that the state attempts to show that there's good cause for delay, we would object. They're required to file an affidavit in response to this, showing under oath what that good cause is. And so they have not done that, so we would object to any showing of good cause. The final matter on this is that under 28.061, the courts have held in ex parte Anthony John Torres, 966 Southwest 2nd, 723. That's a San Antonio Fourth Court of Appeals case from 1998, that it is proper under 28.061 to dismiss with prejudice for failure to timely indict under 3201. And so we're asking this be dismissed with prejudice.
All right. So I've heard both of your arguments. If you just give me a moment to.
Absolutely. I've got case law if you need a judge.
Oh, no, I'm good.
Okay.
To internalize the arguments that have been presented to me.
Absolutely.
And then I will make my ruling, and I'll make my ruling before you leave today.
Thank you, Your Honor. I've got another case, so I'm going to work on that while you're doing it.
All right. Thank you.
Thank you. Ready to step back?
Yes.
Thank you, Judge.
All right. I've reviewed everything and internalized everyone's arguments. And if parties could address this issue for the court, but it appears to the court that your motion to dismiss with prejudice is sort of mute because it's already been dismissed. So,
the judge is in a bind. The case is technically already dismissed, so what's left to? Rule on, but here's the twist defense. Argues the court still has 30 days of power. It's like a video game extra life. The judge has to decide whether to swing the hammer or step back.
Technically, I don't have anything before me because our case has been dismissed. And I understand it was dismissed this morning. And I understand that, it's similar to when you want an examining trial. You file a motion for an examining trial, and then you're down there to have your examining trial, and they're like, oops, it's been indicted. So I understand, but I don't see how I can rule on a motion when jurisdictionally the case is no longer before me. It's been dismissed. I don't have an open case to rule on. Am I incorrect, or is there, you have a point?
In my opinion, Judge, you do have jurisdiction.
Okay.
The court retains plenary power for 30 days after a case has been disposed of, whether it's through a plea, a dismissal, or whatever. And so technically, we could come back and file a motion for new trial and have that considered by the court, and that would still be the same as having this motion in front of the court. And so the court does have jurisdiction to rule on this. The reason we're urging this is the same as any other post-adjudicative or post-dispositive motion, is for the same reason in that we are entitled to have this dismissed with prejudice. We would like the court to consider that. I think the court does have jurisdiction.
All right, State.
I agree with the court's revision that there's no pending matter in front of this court this time.
I'm in agreement that I don't have a case pending before me because the case has been dismissed. So, Ms. Ramirez, your case has been dismissed. There are statute of limitations that are related to this. Okay.
All right.
Thank you.
For considering it, Judge.
Thank you.
Appreciate you.